Texas is an employment at will state. Employment at will means you can be hired and fired for any reason or no reason at all. You can be fired because your employer doesn't like the way you walk, the way you talk, or because they're in a bad mood. Lately, I've been getting a lot of inquiries from employees who've been fired and want to know if there's such a thing as a wrongful termination claim. Can you sue an employer for wrongfully terminating you? Well, if you don't have a contract, and most employees don't have a contract, then you cannot have a wrongful termination claim. You can only have a claim as if your facts fall under an exception to the employment at will doctrine. That means that there are some very narrow exceptions to the employment at will doctrine, and those exceptions usually don't apply, but you need to know them. You need to figure out whether or not you've been fired for any of those reasons. Lately, most of the people that have come talk to me are coming in and saying, I'm fired because my boss doesn't like me. Or I'm fired because we got a new boss in and he or she is putting their people in and moving me out. A conflict with your boss is not something you can bring a lawsuit over. Having a boss bring in a new employee and let you out is not something you can bring a lawsuit over. However, when we talk about the employment at will doctrine, there are exceptions. And there are numerous exceptions. That's why I have paper in front of me here today, because there's so many of them that I can't remember them all off the top of my head. So I'm going to go through those exceptions with you. So you cannot be fired because of your membership in a protected class. A protected class means race, sex, sexual orientation, pregnancy, national origin, religion. For example, under sex, that includes you can't be fired because you're a female. Also under sex, it includes sexual harassment. Sexual harassment means there's two parts of sexual harassment, and that is one is quid pro quo, which means this for that, and that would be that a manager or some supervisor has said they can give you promotion in exchange for some sort of sexual favors. The other one is a hostile work environment. And I hear employees say a lot of times I'm subject of a hostile work environment. Well, hostile work environment only applies to the exceptions that we just talked about. So in the case of sex, if you have a sexual harassment where you're involved in a hostile work environment where they're making sexually suggestive comments, that's what we're talking about. If you just have a general hostile work environment where your boss is being mean to you, that is not an exception to employment at will. Under sexual harassment, a hostile work environment, the type of conduct must be severe or pervasive. Severe means that it's a very serious sexual type of act, sometimes physical touching, and pervasive means lower levels, such as comments over a longer period of time. Other exceptions to the employment at will doctrine include age, disability, genetic information. So if they find out you're prone to a certain type of gene and they don't want to keep you there, they can't fire you for that. Military status. You cannot be discharged for refusing to take a polygraph examination. You can't be discharged in a layoff without them following the Worker Adjustment and Retraining Notification Act. That's very technical. That's something for a whole another entry if we need to do that. Also, note that you can't be fired if you are being fired in retaliation for bringing a complaint for one of the protected areas. For example, let's use race. If someone makes a racial complaint and they have an objectively good faith basis for making that complaint and they're terminated in retaliation for making that complaint, that is actionable. You can bring a lawsuit over that. That's the same with sex and sexual orientation and pregnancy and national origin, religion, all the ones that we just mentioned. So retaliation is actually an easier case to prove because you may objectively believe that you have a good faith basis for going forward with your case, but may not ultimately be able to prove it. However, if they retaliate against you, that's easy to prove. You made a complaint and they fired you because of it. Also, with respect to, an employee may not be discharged in retaliation for making a wage and hour claim. They may not be discharged for participating in an OSHA claim. And with respect to retaliation, all the ones that I just talked about, even witnesses cannot be discharged because they participated. So, for example, if employee A makes a claim based on religion, an employee B comes in and is a witness for employee A and says, yes, I witnessed the employer discriminating against employee A because of her religion or his religion, and the employer says, well, you just participated as a witness and we don't like that, we're going to terminate you. The employee who participated as a witness does have a claim. That is an exception under the employment at will doctrine. If you return from military service, a veteran cannot be let go for a year after returning from duty without cause. So there's an exception for being involved in union activity or acting under a collective bargaining agreement. So if you get fired for that, that is an exception to the employment at will doctrine. So that's why I need this paper. There's about 25 exceptions to the employment at will doctrine. If you're an employee and you believe that you've been discharged wrongfully, and you believe that one of your cases may fall under the exceptions to the employment at will doctrine, feel free to give us a call. We'll walk you through it. There are a lot of administrative requirements, and there's also some really short deadlines. So don't hesitate if you think you have something. Thank you.